December 29th, 2022, Policy and Procedure Committee. And please call the roll.
Ducat,
Yes.
Alt,
Yes.
Sure,
Yes. We do not have a quorum this morning, but I believe we can conduct the business we need to conduct. So. Mr. Waffle is still ill, Mr. Barron's is very busy. Mr. Whitlow may not remember he's on this committee, I'm not sure what his problem is, but anyway. May I have a motion to approve the agenda? Okay, Mr. Hall second, all in favor say aye. Aye. Passes. Any public comment? No public here. Committee chair reports. Mr. Ducat, Health Committee.
Health Committee,
Tax Committee.
wasn't a whole lot for health, just Adita's reason. She's
We're
retired.
just taking here in the standard reports.
Okay.
Tax, Tax Committee,
Good. She's,
same thing.
Yeah.
No issues,
no
no
issues.
problems.
No, everything went good.
Highway Committee, Mr. Hall.
We have only the normal claims to take care of this time. There's nothing special on the agenda as of yesterday.
Everybody's in a festive mood, trying to slow and easy. At this
I don't
time.
ask questions like that when they're running snowplows.
Oh,
I will ask when they get to my driveway, and they never do.
you never get to your driveway. Don't they know who you are?
But I'm the top one on their list as far as the county board is concerned, if they ever get that far.
Okay. I don't have any comments this morning either. Mr. EMA. Here,
Yeah,
you should give us a report.
yes, sir.
Wasn't here last month, so we need a good report today.
Yes, sir, I can do that. The hazard mitigation grant that I applied for, I received word from, the hazard mitigation people at the state level that FEMA has accepted our grants. And they told me just to hold off on any planning activities. They are working on executing the grant to us locally. So that is coming. It is approved by the federal government. They forwarded me the letter from the federal government approving it. And now I'm just waiting for their execution of it, which is the state sending us the formal approval as well, their approval. So that is coming. And then my first step, once I receive that, will be to send out a request for proposal for a contractor to help with the hazard mitigation plan. I've already got a draft of that request for proposal. I'm gonna work on tweaking it a little bit, run it by the state's attorney, and then once I get that execution, we'll proceed forward. Other state requirements that I'm working on, the ILCAT, Illinois Capability Assessment and DIBRA tool, they issued a new format of that, and they're requiring me to update that. So we've been working on that, it's nearly done. In addition, NIMS certification, National Incident Management System, every couple of years, they want me to fill out a survey, which I have to gather a lot of information from local elected officials and so on and so forth about, are they NIMS certified? NIMS, if, for new people and for people that have been around for quite some time, is a National Incident Management System. And the federal government requires that all local governments are NIMS compliant. Elected officials don't often have to use NIMS, but there are they're free online FEMA courses, and I do recommend that elected officials take NIMS at least 700. But we can talk about that later. It gives a good overview of the NIMS systems, what happens during disasters and regular emergencies, what elected officials at least need to know how things proceed. So, working on that. And early next year, the county emergency operations plan is due to the state. The last time it was updated was 2021. So this is just a regular update that the state wants. So, working on that. Looking forward into the next month, on the 10th, no, not the 10th, excuse me. Next week, I have a webinar scheduled with Illinois Emergency Management Agency. They haven't discussed this, but they sent me the web link along with other EMA coordinators. And they titled it IEMA Rule Changes. This just gets me a little bit nervous because whenever IEMA starts to change some rules, it could mean more requirements on local EMA. So I'm going to attend that, and
What else could it mean?
it could mean anything. Honestly, I don't know. I haven't been given any context yet, but I'm giving you all a heads up. And if it's anything important, then I'll report about it next month. I'm just a little nervous about it. But that is what EMA is about.
Okay, does anyone have any questions? Mr. Sissi? I have one question.
Sure.
How about your vehicle?
The EMA Suburban's doing well. Check engine light is on, but seems to always be on. It's an older vehicle. With the new budget, I'll be scheduling an appointment over at Jolly to get the AC fixed at the county board. I explained to the county board during budget time they need a little bit more in maintenance for that automobile because the AC was broke, and that it's a bit troublesome in the summer, so I get that scheduled. Is there specific use you need of the vehicle, sir?
Well, I think that, like you said, that's an older vehicle. I think it's important that we kind of stay up to date on the condition of it and the future of it and so forth. That vehicle was donated. What does that mean when it comes to the end of its life? Are we gonna be required to replace it? And where are we gonna find the money to do that?
All good questions. I will say that the county board is not required to provide EMA with a vehicle. But at times when EMA was not provided a vehicle, we relied on the director having a personal vehicle that was available, doing what needed to be done. Mainly, the concern is having some towing capability to haul necessary assets during disaster and being able to get places when weather is adverse, such as 6 inches of snow and whatnot. That's a conversation for a different time. But I will say that EMA does not use vehicles as hard as other departments. The EMA Suburban will sometimes sit for a week or two before it is needed. But when it is needed, such as the gas pipeline that broke, that 4x4 came in handy when we had to drive out into the middle of a muddy field to find more gasoline spilling into a creek. This past winter storm, I made sure I took that Suburban home in case I needed to set up a shelter during the middle of the storm. So having 4x4 and towing capability is the main benefits of that vehicle, and we're doing our best to keep it in tip-top shape.
I think that it's important that we do recognize that situation and keep up to date on it because, as I said, it's not gonna last forever. And when it gets to the end of its useful life or whatever that decision is made, then we have to see where we're gonna go from there.
The last time the check engine light was on was this past year, and it was due to the fuel being too lean. I took the trolley, they replaced a part. Within a month, it came back on. So I'll be having them check that out again. I imagine it's the same issue, which fuel being too lean can be.
It's also common in older vehicles for the catalytic converter to cause that.
Yes.
Too.
That vehicle has, I want to say 80-some thousand miles on it, which not too bad. And most of the time it's kept in the shed next door. Right now it's outside because the sheriff needed the space in the shed, so.
I saw where it's parked this morning. Terry?
Wouldn't it be wise to put it in one of, not this year, but a future budget? Purchase of a new one and keep your eyes open, see a good deal, you're ready for it.
Well, I think that's a good point. I'm not just sure what the best way is to handle it because a new vehicle like that's gonna cost a pretty good piece of change. And if the old one is worth practically nothing, it's not gonna get, you're not gonna have a trade-in, so you're gonna have a pretty large expenditure.
I don't take it.
And you
If
said
you were
one of
gonna-
the things
if you were
they
gonna
could
buy a
probably
brand new
worth
one.
nothing. They should get rid of like before, basically, we're talking nothing. Well, a new one, or a different one, put it out.
There may be other options, for example, there are times when the sheriff has older vehicles that could be used, there's also
If
the
you're in
coroner,
the budget, you can do it.
the coroner has.
I don't care where it comes from.
Right.
Taxpayers.
I think that's something we need to do, so I brought it up. Okay,
How many miles are on?
I think around, in the 80,000 range.
80,000
A
range,
little
so
over 80,000.
sometimes in an older vehicle, there isn't so much miles, just sitting there,
Right.
whatever, the weather and all that can take its toll.
have you thought about taking somebody they have just looked at to see what the check light is?
I'll be doing it soon.
He's gonna go to Jolly's.
Okay.
And it's running I took it to a Mavis meeting in Piper City last night, it's running just fine. And I haven't had any severe problems with it in over a year. It's doing well right now.
I wasn't trying to create a problem, I'm just saying.
No,
we need
I
to-
sincerely appreciate your attention to the matter.
We need to keep our eye on it, that's all.
And I sincerely appreciate your attention to the matter, because I don't wanna go back to the days where I need to make sure that my personal vehicle is ready to do EMA activities. Mileage reimbursement is one thing, but needing to maintain and actually acquire a vehicle capable of doing what EMA needs for personal needs, a bit strenuous, so I appreciate your attention to the matter, Mr. Chair.
Okay. Next we have a discussion on the Facebook page. It's my understanding that we haven't been able to really get much done this past month. Amanda's been ill, holidays and all that's interfered, so we'll table that till next month. We're basically trying to learn what the nuances and details are of the Facebook page that the health department, the EMA, and the sheriff's department have on their pages, as well as what some of the adjoining counties have and whatnot, so that we can get some guidelines as to what we might want to do and so far as one for us. We also have to make a decision on that in regards to if it will be a Facebook page of the county board or of the county in general. Those are a couple of things for the committee to keep in mind. Update on sexual harassment training for 2023 coming up.
Well, for 2022, we ended at 90%. I have two departments that I didn't get anything turned in for. One of the departments has a lot of contracted part-time employees, so I've talked to department head about how we can maybe get that up for 2023. 2023 stuff will be coming out in an email sometime this week. I want to say today, but I'm not gonna promise it, so I will definitely have it out by the end of Friday. That's where we're at.
What are we planning to do for 2023? Something like what we did this past year?
Yep.
Be available online, or it'll probably be a training here.
Yep, I can set up some training, sessions here. Basically, it's the video and then, follow-up certification afterwards. We'll probably set that up, I would say.
Seemed
Couple
to be
months
the
into
ones that we
23.
had set up here last year weren't quite as well attended those.
If we're not.
I think that's something to take into consideration.
I'm open to suggestions.
Well, maybe we should,
I mean, I could send the sheriff out and just have him start bringing everybody in.
yeah,
Yeah.
that might work.
Whenever he's got time to do that.
Yeah.
But yeah, that, again, there's multiple options available. You can watch it online yourself, you can watch it here. I can put it on the big TV a couple times like I did last year. Whatever helps, I'm willing to do, so.
Well, I guess my thought or suggestion would be to repeat what we did last year and measure its effectiveness and then use that as a gauge if we need to make changes, although if any of the department heads have suggestions on how they can best get their department to comply, I think that probably would be a good thing to try and get established or cooperated with or whatever, but as far as the sheriff goes, I guess if he's got time, if not, Amanda can chase him, and she's pretty good at that too.
Well, I know she doesn't have the time.
Okay, that brings us to the main focus of the meeting, which is to get back onto this personnel policy manual. I know last time we skipped over a couple of pages. Are we ready to go back to any of them, or are we?
Not yet. So we're going to start where we left off, which is, yeah, leave of absence, bereavement, okay?
Let me see the one for this.
What did you get? So, let's see here, personnel leave of absence bereavement, this is policy number 1029.
What page?
Page 59.
59?
Doesn't have a number on it.
Look for policy 1029, Charlie. See how it says here,
What's the
1029?
page number?
59.
Go to page 58 and then take the next one, just doesn't have a number on the bottom.
On the bottom.
That looks like it's.
Sure, that's what it looks like.
Small.
It's very small, yes.
Did you open it right up to the bright page?
Yep.
A little bit different.
Try to find for you.
There's no number on it.
You see it all.
Look right here, Charlie. So you see that?
That's the same, but don't have a
Right
number.
here. Look right here, this number
That's
here.
it. But it doesn't have a number
1029?
on it. Doesn't have a number at the bottom.
No, it's printed,
I got it.
it's
Found it?
very odd format. Look at you, open right up to it. All right, so under policy, let's see here, we're striking out, she would like to strike out for a grandmother, grandfather, brother-in-law, or sister-in-law. And just leave it at full-time employee may use up to 3 sick or vacation days off to attend a funeral or other services to grieve the loss of or to attend to business necessitated by the death of a grandmother, grandfather, brother-in-law, or sister-in-law. Okay, so she's just moving that part of it from the beginning to the end of that sentence. Are we okay with that?
Well, the part that's underlined is being added in.
Yeah, she basically took out what was in the beginning of the sentence and moved it to the end of the sentence.
The part about other services was never included before, so that's
Right,
included now.
right, but sometimes they don't have a funeral, sometimes other religions.
Right, I understand.
Okay, so we'll leave
The
that.
only other part about that I would say, I don't know that we've ever had a policy on was the businesses. I mean, if you gotta go to the county clerk's office to get a death certificate or something like that, is that what's included there, is that right? That's other
wouldn't-
business, are you gonna meet with a lawyer to,
I wouldn't begin to dictate what kind of business is involved with somebody's passing.
if you're,
I don't know, maybe they have a child that they need, you know,
if you're the executor of a will and you're gonna have that hearing or something, that you get time off for that,
allow you 3 days to do whatever you need to do.
that's sick or vacation time. Just so we understand what we're doing there, because I don't think we've ever had that aspect of it included before. I'm not sure how, if people took the time off, they probably took sick leave or vacation time, didn't they? In the past,
I'm
Yes,
assuming, so yes.
so,
that is true from what I've seen, Mr. Chairman.
okay. Just so we understand what we're doing.
Okay, so, let's see here, what do we have under here? Alright, So child bereavement, these provisions track the Illinois child bereavement law, but note that this leave is only available if the employee is an eligible employee for purposes of FMLA. To be eligible for FMLA, an employee must have worked for at least 1 year. The employee must have worked 1,250 hours in the previous 12 months and must work at a site with 50 or more employees. So child bereavement leave states eligible employees as that term defines section 101(2) of the Federal Family and Medical Leave Act 29 USC 2601 are also entitled to take a maximum of 2 weeks, 10 working days of unpaid bereavement leave to attend the funeral or alternative to a funeral of a child, make arrangements necessitated by the death of a child, or grieve the death of a child. In the event of the death of more than one child of 12-month period, an employee is entitled to up to a total of 6 weeks of bereavement time during a 12-month period. Bereavement law under this child bereavement policy must be completed within 60 days after the date on which the employee received notice of the death of the child. An employee is required to provide the county with at least 48 hours advance notice of the employee's intention to take bereavement leave unless providing such notice is not reasonable or practical. The county may require reasonable documentation, including death certificate, a published obituary, or written verification of death, burial, or memorial services from a mortuary, funeral home, burial society, crematorium, religious institution, or government agency. An employee who is entitled to take paid or unpaid leave may elect to substitute any period of paid leave for an equivalent period of unpaid bereavement leave. The county prohibits retaliation against any employee who exercises his or her rights under this policy, opposes any practice that the employee believes to be in violation of this policy, or supports the exercise of rights of another under this policy.
Question. Back on the first paragraph that you read there at the end where it talks about in the event of the death of more than one child in a 12-month period. The way that's written, it's assuming one child is a singular event. If you have two or more children that die in the same, let's say in an automobile accident, how does that treated? That's one event. Is that entitled, because it's 2 children within a 12-month period, do they get 6 weeks off?
My feeling is that they just need more than one event in that case. I give a partial of 2 or a full 2. I mean, this getting ridiculous in what we're doing.
Well, I understand your point. On the other hand, these are situations that could occur, and I'm just asking a question. How would we handle it?
In practical use, I'd be hard
In
pressed.
my opinion, if they've lost 2 children, then yes, they have the 6 weeks.
Yeah, 2 children at the same time.
It wouldn't matter either way, yeah.
Okay.
That'd be my opinion.
I'd agree with that thought process. I mean, generally speaking, the death of a child is probably going to be a pretty lasting moment on almost any parent, so if they need any mental health services, etc., afterwards, they're going to have to arrange that with FMLA or something else regardless.
I'm very well versed in the loss of a child. Okay. Having experienced that myself. But that doesn't detract from my question.
No, it does not.
That's fine if that's the way we're gonna treat it, so, it doesn't really specifically state it that way. That was the reason I brought the question up. Go on to the next one, Joe.
All right, leave of absence, FMLA, this is policy 1030. She has a comment here under, let's see here. FMLA also requires that to be eligible for leave or employee work at a site with 50 or more employees. I recommend also including this requirement for eligibility. Okay. So provision for leave, let's see, number 2, striking the onset of a serious health condition that prevents an employee from performing the essential function of his or her job. And just changing that to state for the employee's own serious health condition. Are we okay with that?
So,
Let's see here. Okay, so under the section amount of granting of leave, paragraph 2, adding in the county uses the rolling backward looking method for determining the available FMLA leave in a 12-month period, except in cases of leave to care for a service member. Okay. Upon request or qualification, an employee is entitled to a maximum of 12 weeks less any family leave taken in the previous 12 months. An eligible employee will be required to exhaust any vacation, personal, or as applicable sick time before she can take FMLA leave on an unpaid basis. In other words, paid leave will run concurrently with unpaid FMLA leave. For FMLA leave requests made to care for a covered service member with a serious injury or illness, the single 12-month period begins on the first day the eligible employee takes FMLA leave.
I guess that works.
Let's see, while on leave. Well, comment made here is if an employee is on paid FMLA because they are using vacation or other paid benefits, and you would allow employees to continue to accrue benefits if they were taking paid leave for other purposes, then I would recommend applying the same standard for FMLA paid leave. It currently states all other benefits will not be continued or accrued during the leave, but may be continued if a particular benefit plan specifically authorizes benefits for employees on unpaid leave. Working another job while on leave of absence is prohibited and will be cause for disciplinary action up to and including discharge. Failure to communicate and return from a leave of absence on the date will, striking out will, but adding in may be considered job abandonment and make the employee ineligible for rehire. An employee unable to return within the approved leave time frame should contact the county to determine if the employee may qualify for the other benefits, including but not limited to reasonable accommodation under the American with Disabilities Act or Illinois Human Rights Act. They struck out the sentence saying will have to resign and may reapply for employment. Just gonna keep going. If you guys wanna stop, go ahead, let me know.
Yep, go ahead.
Okay. Moving on, under procedure, this would be letter C. All leaves involving a serious health condition, striking out, or birth of a child require medical certification from employee's healthcare provider to substantiate the existence of a condition requiring the leave. Strike out the sentence, in the event of the family medical leave is for the employee's own care, her healthcare provider may also certify that she cannot perform any job or essential functions of his or her own job. Iroquois County has the right to obtain a second medical opinion regarding the necessity for an employee to take family medical leave at county expense.
You don't say why we're crossing that out?
There's no comments. Well, I'm sure that the strikeout of the birth of a child, because didn't we had something similar to that prior?
Yeah, no, I'm talking about in paragraph C there, she says the sentence that struck out there.
Yeah. Yeah, there's no comments as to why. Would you like me to keep going? Or any thoughts on that?
I mean, I don't understand why that whole sentence is being crossed out. That's something that, you know, was put in there for a good reason when it was put in there. Why is it being taken out?
Well, I think it might be just because it's kind of saying the same thing. All leaves involving a serious health condition require medical certification from the employee's healthcare provider to substantiate the existence of a condition requiring leave. So that covers the employee's healthcare provided, and then I guess in my opinion, it's saying the same thing by restating that if it's for the employee's own care, the healthcare provider must provide certification that they cannot perform a job. I don't know, maybe it's just kind of meaning the same thing there.
Well, okay, if we think, you're talking about the preceding sentence.
Yeah,
Yeah, if we think that's okay, I guess that's fine.
I mean, that's just how I interpret it, it's not by all means.
I think a lot of these things, you know,
And don't
in a
know.
sense, fall under department head and Amanda as far as interpretation goes in situations. I don't know if there's any of these things that have come before the board, or they could, I guess, but they haven't in the past.
Okay, paragraph E, striking out before an employee can return and including when an employee takes FMLA leave for the employee's own serious health condition, Iroquois County requires him or her to submit a fitness for duty certification from his or her healthcare provider to the effect that he or she is able to resume the essential functions of their work with Iroquois County. Let's see here, the comment made, comment made on there states, the Department of Labor has updated the sample forms, here's a link to the most current forms. So we may want to get the most current forms for the family medical leave, information that needs to be filled out, which is okay, we can do that.
Sounds good.
So then we're moving on to, let's see here. There's also the form here that they say to get the updated version, which is not a problem, we can do that.
64 and 65 is all part of that form. 66.
We're all the way down to page, let's see here, 70.
A lot of forms.
Holy moly.
Better not get sick.
That's a lot of empty pages.
You do?
Yes.
Uh-oh. Alright, so going down to, let's see here, page 75, at the top, it's gonna say policy number 1031.
There's the 71.
Yep, keep going, you're almost there.
Yeah, but this is ridiculous. 72. What do you want?
It is a policy number at the top here, Charlie, 1031, it's on page 75.
I'm coming to it.
I know you are, you're almost there, keep going. Right there, stop,
No,
on the other page, nope, stop, other page, the one that you just flipped over. There you go.
okay.
Alright, this is leave of absence holiday. Excuse me. Nothing, okay, so under procedure, letter C, forfeit, and underlined here, addition is of holiday pay for the reasons set forth above, also will be noted in the employee's personnel file, so if there's any forfeiture of holiday pay for any reason, it'll be in their file. Which, okay, don't know if it would ever happen, but. Okay, so, page 77 is policy 1032. The only thing there is on the very last paragraph of that page, she's changing the word will to may. That's fine. And then on the next page, the first paragraph, Failure to return from a leave of absence on the date specified may be considered job abandonment and may make the employee ineligible for rehire. An employee unable to return within the 30-day period frame may be terminated and may reapply for employment. Working another job while on leave of absence is prohibited and will be cause for discipline up to and including discharge. Moving down to responsibility, letter B, the comment made here is, she has a question about a written request. So the paragraph reads, it is the responsibility of the department head or supervisor to review each case of an individual basis. In the event the employee's need for the leave of absence is immediate, the department head or supervisor is responsible for obtaining it from the employee. Verbal agreement is acceptable with a witness in extreme circumstances with proper documentation. I don't like that. I think that it needs to read, in the event of employee's need for leave of absence is immediate, the department head or supervisor is responsible for obtaining written documentation from the employee. I don't like the verbal agreement, so I'd like to strike that if that's okay.
Is it obtaining or obtaining?
What do you like better? So I'd like to strike out that verbal agreement and.
Understanding in the English language would be obtaining.
Yeah, it would be. Written request.
But I agree about taking the verbal part out.
No, we don't like to do verbal too much. Alright, so moving along, let's see here, page 79. So this would be policy 1033, which is leave of absence military. Under section purpose, she is striking out the first sentence and instead changing it to state that employees will be granted leave in accordance with federal and state military leave of absence laws. Okay. Let's see here. Under policy, second paragraph added in with the sentence, a military leave of absence will be granted to employees who are absent from work because of service in the United States Armed Forces in accordance with the Uniformed Services Employment and Reemployment Rights Act, USERRA, and the Illinois Service Members Employment and Reemployment Rights Act. Say that 10 times fast. Alright, so the next paragraph here, the comment being made, it states to see section 510 of the ISERRA statute for provisions relating to concurrent or differential compensation for public employees. So, I'm gonna read this paragraph as she recommends. And it would state, depending on the length and type of service, the employee may be eligible for unpaid leave, concurrent compensation or differential compensation in accordance with the applicable USERRA and ISERRA provisions. However, employees may use any available vacation time for periods of unpaid leave or during periods when differential compensation would be owed. Employees must notify the Iroquois County Board Executive Assistant if they are electing to use vacation time. Continuation of health insurance benefits is available as required by USERRA and ISERRA based on the length of the leave and subject to the terms, conditions, and limitation of the applicable plans for which the employee is otherwise eligible.
I have a question going back to the previous paragraph.
Sure.
The last sentence says advance notice of military service is required.
Unless military
I'm joining the Army in 5 minutes, is that advance notice?
advance notice of military service is required unless military necessity prevents such notice or it is otherwise impossible or unreasonable. So basically, it is preferred, but we can't really enforce the time limit of it.
I understand when people are called to active duty if they're in the reserves, but if I was joining the Army, I'm supposed to give you advance notice. If I tell you 5 minutes before I'm leaving for the train, is that advance notice?
That's all you had, that's what it is.
No, you have more than, if you're enlisted, you have a lot more than 5 minutes.
You have an option either way. I mean, if you tell me, hey, I'm going to the military in 5 minutes, and I say, oh, no, you're not, are you gonna listen?
Well,
I mean,
guess
it's
guess
just
the purpose-
insinuated that it's preferred.
the purpose of my question is, from the standpoint of the employer,
Mm-hmm,
when someone is leaving, you like as much advance notice as possible
Well, of
so that
course.
you can prepare for that. If somebody comes in and says in 5 minutes or tomorrow I'm leaving, that doesn't provide the employer with much of an opportunity to prepare for it.
absolutely not. I think we are in any situation, we like to have a little,
That's why I'm questioning that wording in that sentence.
you have any suggestions on how you would like to change it?
You know, in other cases, we talk about like getting 2 weeks' notice, don't we?
As it being preferred,
So do
yeah,
you want something as soon as the employee knows?
it basically says that.
Maybe nobody knew it till.
It's just basically,
If you-
it's
if
basically
you
stating that it's
enlist,
a
I'm talking
preferred
about when
option.
you enlist. If you're a member of the reserves, the National Guard, and the governor calls you up, yes, I understand that, we all understand. I'm talking about somebody goes to enlist in the service. Okay? Let's say that Eric Stacy decides he's gonna join the Army. When is he gonna let us know about it?
Because you legally have to.
Is he supposed to let you know he's planning on it?
Well, when you
You're not
enlist, you
legally,
sign.
you're not legally obligated to do anything. If I could say today, hey, I'm leaving, today's my last day, I took another job, what are you gonna do about it, sue me? I mean, there's no legal obligation to anything. It's pretty much in the manual stating, hey, we prefer as much notice as you can give us, but there really isn't anything we can do if you don't give us any notice.
I understand that part, but the very fact that it says in there about that notice encourages employees, and in many cases, employees will comply with that.
Mm-hmm, absolutely.
I mean, in essentials,
That's why I think there should be
Maybe
something
he
in there
can't.
to that.
I mean, in its essentials, you may as well create a section for common
Yeah.
courtesy.
When you enlist in the Army, you sign paperwork and you say, okay, you're going to Fort Leonard Wood 2 weeks from tomorrow.
So,
So as soon as you sign the paperwork, you can tell the employer, I'm joining the Army and leaving in 2 weeks.
what if he calls you the next day and say, we had an early in for you because we can take you right now today. The service can do anything they want to.
People really do, you know.
Okay,
Whether it's right or wrong, I mean, and like I said before, if you have any suggestions, I'm open to it, I don't care, but I think it basically says, hey, give us some notice if you can.
okay. I guess we'll move on.
Policy 1034, so this would be, let's see here, page 81. There's no markups in the previous policy. So page 81, this is leave of absence, sick, policy 1034. Under policy, first paragraph, sick leave is employee income sick leave is employee income protection for illness or injury or medical appointments that cannot be scheduled during non-working hours and may not be paid for any other reason. Moving down here, the comment is provided, employers can choose the limit to the amount of sick leave that can be used to care for a family member to an amount that is accrued in a period of 6 months. The added provisions track the Illinois Sick Leave Act. So the paragraph, she added in the condition from the Illinois Sick Leave Act. So it states, sick time can be used for employee or family member illness, injury, doctor and dental appointments, or for the personal care of a family member. For purposes of this policy, family member is defined as an employee's child, stepchild, spouse, domestic partner, sibling, parent, mother-in-law, father-in-law, grandchild, grandparent, or step-parent. For purposes of this policy, personal care means activities to ensure that our covered family members' basic medical, hygiene, nutritional, or safety needs are met, or to provide transportation to medical appointments for a covered family member who is unable to meet those needs himself or herself. Personal care also means being physically present to provide emotional support to a covered family member with a serious health condition who is receiving inpatient or home care. Employee supervisor may require a physician statement for absences of 3 consecutive days or more, or if abuse of sick leave is suspected. Abuse of this policy may be cause for disciplinary action.
Sounds good.
Okay, the next comment on the following paragraph states, does this mean that it may be used for IMRF service credit upon retirement in accordance with IMRF rules? If so, I would recommend revising to state this. So paragraph, I'll read it as she recommends. Sick time may be accumulated up to 60 days. For IMRF purposes, all sick days in excess of 60 days will be kept as a benefit for retirement purposes. Any employee who has more than 30 days of sick time on November 1st may request to be paid half of a day's pay for each sick day not used in excess of 30 days. The request must be received in writing by October 25th, and payment for the time will be on the first paycheck in November. Accumulated unused paid sick leave shall not be paid upon voluntary or involuntary termination. Employees going on approved non-FMLA medical leave of absence must exhaust all sick leave before the leave of absence will begin. Employees on FMLA leave must use sick vacation days concurrently with unpaid FMLA leave.
This pretty much mirrors the union contracts, does it not?
Yeah.
So I thought, so.
Okay, moving on to, let's see here, so number 2, there is a comment provided, this seems like it should be under a separate heading. So, IMRF provides 2 types of disability benefits. The first one being temporary, when a member is unable to perform the duties of the position which might reasonably be assigned by the current IMRF employer. Excuse me. Number 2, total and permanent. Paid after temporary disability benefits have expired and if the member is unable to engage in any gainful activity from an employer. I don't think it needs to be separate because it's temporary, total, and permanent. That makes sense to me. So, I would like to leave it as it is if that's okay with everybody.
Yeah, I don't understand why it should be
I don't
separate.
either. Alright, moving on, this is policy 1035, leave of absences, VESA, Victims Economic Security Safety Act, which is page 83. Makes a comment here to see sample policies, so I will have to get a sample policy. So, we're gonna table that one, and go to the next policy, which is personnel meal breaks, number 1036, this would be on page, 85. Which makes a comment here under policy that states unclear what is meant by this, so let's read it. Each employee scheduled to work more than 5-hour shifts is entitled to an hour unpaid meal break. During meal break, the employee will be uninterrupted and be completely relieved of duty. If the meal break is interrupted by the necessity to return to work, the meal period becomes work time and will be paid or comped. I don't understand what she doesn't understand.
I don't think you understand the word comp.
Carl time is?
Um,
Okay, so we can change, compensated, we can change it.
yeah, just change the word.
Moving on to page 86, which is policy 1037, nepotism. There's a comment under policy that states grandparent as well. Also, or where a relative has control over the terms and conditions of the employment. And I'd recommend stating that the county reserves the right to terminate one or both employees. So, a relative is an employee's father, mother, son, daughter, brother, sister, uncle, aunt, niece, nephew, husband, wife, domestic partner, grandchild, first cousin, father-in-law, mother-in-law, son-in-law, daughter-in-law, brother-in-law, sister-in-law, stepfather, stepmother, stepson, stepdaughter, stepbrother, stepsister, half-brother, or half-sister. And then including the, looks like we left out grandparent. Okay? Employees are not allowed to work in a position where their supervisor is a relative or where a personal relationship interferes with job performance or morale. No person should be hired for a position when to do so violates this policy. If such a situation is created through promotion, transfer, marriage, or other changes, one of the affected employees must be transferred or resign within 30 days after the relationship is established or becomes known. I'm just gonna keep going to page 87, which is personnel on-call policy number 1038. And under policy, there is a comment that states you may want to specify what this would be. So the policy states employees who are required by the supervisor to remain on call after their regular workday or work week should be available by cellular or phone. Employees are expected to respond to the call and travel to work within a reasonable amount of time.
Comes that word reasonable.
You wanna keep this as is? Do you wanna make any changes? I think we could probably leave it as is and leave the word reasonable up to interpretation by the department head or supervisor. In my opinion, but
Well, I'm playing on the golf course, I got 11 holes to go yet.
that's not reasonable. Whatever you wanna do with that, I don't have any opinion.
I just do not like that word. In this context.
Is there any way you wanna change that sentence, or do you wanna leave it as is? What are your thoughts?
Personally, I would like to change it, but I don't know what I would like to change it to, because I'm not sure that I know what would be reasonable.
All right,
But
moving along.
certainly reasonable is a very vague term that's
It
open
is.
to interpretation. Doesn't really accomplish much. If you're calling somebody in for work, you must have an urgent need for them to be there.
It depends on whose interpretation is correct, and in that case, it'll be your supervisor or department head. Okay, so then we're just gonna leave it in, because we don't know what else to change it to?
I guess so, I guess
Okay.
as time goes along, if we run into problems with it, we can have to address it at that time.
Sure.
If somebody has a suggestion, but.
Sure. The next comment she provided, I think this needs to be clarified. An on-call employee generally does not need to be paid if they are on call at locations other than the work site and can use their on-call time for other purposes unless a collective bargaining agreement provides otherwise. But you must pay employees when they are called back to perform work, and if an employee must remain at the work site and cannot leave while on call, they must be compensated. Here's a link. Da. So what she's saying here is, let's see. Employees must be fit for duty during working hours. Fit for duty means being in a state of physical or mental health that facilitates the performance of essential job duties in an effective manner and protects the health and safety of oneself, others, and property. Working hours begin with an employee's starting time and end with an employee's quitting time, including any time an employee is on call. All work activities are included whether or not they occur on county premises. Just remember, this might go hand in hand with the collective bargaining. Because when we talked about, let's say like the FOP contracts, they're not, their work activities are obviously sometimes not on county premises. But I think this kind of mirrors them. Okay. Alright, So page 89, this is gonna be the policy of overtime, number 1039. Under policy, very last paragraph, she is reorganizing the paragraph here to state, in accordance with the Fair Labor Standards Act, the county will pay a non-exempt employee overtime for hours worked in excess of 40 hours, in excess of 40 in a work week, unless otherwise noted in bargaining unit agreements. Pretty much what it said prior to that, it looks like, only it's just reworded.
Okay, but the 40-hour work week, most of our work weeks are 35 hours.
Unless otherwise noted in a bargaining unit agreement, so if like ASME union contract, it's 35 hours.
What
And
about people?
the regular time, refresh my memory, regular time up to 37
37 and
half, and then after 37 and a half, they get overtime.
What about people that aren't covered by the union contract?
Trying to think if there's anybody that's not covered by the union contract that's not salary,
chief deputies.
chief deputies.
I think they're usually
What
treated
about Chris
Treated
Reed,
like
like
they
they
were.
was out plowing snow out here, is he working
I mean,
overtime?
he's salary,
But he doesn't get overtime, even though he'll be out at more than 40 hours.
unless otherwise stated in a collective bargaining unit or contract.
What about the
Well, then he
hourly and
he doesn't get any overtime.
which is the time of day, just available.
I don't know, I mean, I'm open to, if you wanna change that, I don't necessarily have an opinion either way.
Well, okay, well, take the example of talk about chief deputies. What about when there's an election, do your chief deputies work overtime?
Yeah.
When do they get, where do they, when, how many hours till they get into overtime?
How many hours?
Yeah.
We have always followed, chief deputies follow what the union contract goes by, so 37 and a half hours. That's what we've always gone by, because we have a 35-hour work week, we don't have a 40-hour work week.
So maybe the 40 hours here, this should be changed then.
Well, there are some departments that do work 40 hours, so you're dealing with different hours all over the place, because I believe health department works 40, right? Yes, no?
Most health,
They're
most-
35?
they're 35
Okay,
with the exception of, current administrator.
okay,
But
okay.
I work 40-hour work weeks, because I need to do 20 hours at the health department, 20 hours at EMA,
Okay.
but I'm salaried, so.
But it does say, unless otherwise noted in a bargaining unit agreement.
I'm not sure what we're talking about people that, I mean, this is a people
Oh,
that are
highway.
involved in the.
Highway is 40, they're 40.
They're 40 hours. So like Doug, except he's salary, I'm sure, for what he makes.
But they get overtime,
Mm-hmm.
so he's not considered salary.
I hate all the different. Yes.
Only salary person
I know.
would be Joel.
Yeah, Joel's the only salary person out there.
Okay, so
They're
Doug
all
works a
covered.
40-hour work week,
They're all
so
covered by
if
the.
you're gonna have two different.
Right, they're all absolute, so they do get overtime.
Which goes back to the union.
Right, but the question is, non-union people, when do they go on overtime? Chief deputies are going,
After 57 and a half hours.
which is not 40 and so should we change the 40 to 37 and a half? Or are there non-union employees that have to work 40 hours before they go on?
So then change it to state in accordance with the Fair Labor Standards Act, the county will pay non-exempt employees unless otherwise noted in a bargaining unit agreement. You don't have to specifically state how many hours, you just go by the Fair Labor Standards Act or their bargaining agreement or contract.
Their labor standards act says 40 hours.
Right, I know, it's ridiculous.
Open
I get what you're-
suggestions, how
I
would
get
you
what
like to
you're
change
saying.
it?
Right, I know.
As long as it says otherwise noted in the bargaining unit agreement.
No, but talking about people that are not covered by that agreement.
I'm not covered by agreement, I'm not salaried.
Everything that we have here,
Since you're,
everything that we have here is superseded by the bargaining agreement anyway.
Right.
So, if you think it should be left at 40, I guess that's all right, but if we're paying them after 37 and a half, to me, that would be,
Open to suggestions on how you wanna reword it.
you know better than any of us, Amanda, is there any employees that are non-union employees?
I'm a
Amanda?
non-union employee, I am not salary. I don't receive or I am not able to receive overtime. But I do work, I comp my time. So I'm like the exception to the rule.
Okay,
Why would you not be able to take overtime pay?
We don't budget overtime in our budget.
So instead I allow her to get up to 14 hours of comp time.
But I think it's a federal law that you have to be offered either the pay or the comp time.
Right,
As far as-
yeah, we do, we
Right.
just do comp.
So I'm just saying, that's not technically true, that you
Right, I'm not,
can't get paid overtime
right,
because you have to. Okay,
She's thinking of that option.
well, she should be. But you don't want that option, I'm assuming, that's why you don't budget for it and you just take it
but
off.
if you wanted that option, then it would be after 37 and a half
it would be
hours.
after 37 and a half hours, yes.
My question again, are there any non-union county employees eligible for overtime that have to work more than 37 and a half hours in order to gain that eligibility? In other words, have to work 40 hours, non-union.
That's all would be the only person that, right? You said he has to work 40 hours.
But he's union.
Doug is union?
He's asked me. He's asked me.
Doug? Are you sure?
All highway, besides Joel, they're all asked me.
Really? I don't think Doug ever was in the union before.
No, I thought
I
I'm
won't
all,
argue with it, but. Do what?
Get a break up for 35 hours.
I mean, my, just in the
They're
interest
all
of
included
accuracy,
in-
if it's
they're
37 and a half hours, then I'd say we should change it to 37 and a half.
and we can,
Right, and that's what they currently get.
Makes sense.
No, they get it
my
at
only thing is
37.
if the Fair Labor Standards Act says 40,
Right.
then if you put in 37 and a half, then that doesn't comply with the Fair Labor.
I think you need to make a decision what it says, and then you need to make a decision as the policy and procedure committee if you want to include your non-covered union people that want to work 35 hours a week to follow the union agreement, which is what we've always done. We've followed the union agreement.
Yeah, they have to.
Right.
Maybe not have to, but they do.
I wouldn't change the wording of what it
The
states in the Fair Labor Standards Act.
Well, that act, I think if you read that act carefully, you could, if you had somebody that worked 20 hours and you wanted to start paying them overtime, you can do that. You can't go beyond 40 hours in a week. And once you get 40 hours in a week, then you have to pay overtime according to that act. You can pay it ahead of time if you want. You can pay somebody anything you want if they're a non-union employee. That's.
So what would you like me to do with this paragraph? Leave it? Change it?
Say
What's your
again
suggestion?
Say again what you wanted, what you thought would be good.
I just made the suggestion if you wanted to take out any sort of numerical values and just leave it as in accordance with the Fair Labor Standards Act, the county will pay non-exempt employees overtime unless otherwise stated in a bargaining unit agreement. I just suggested if you wanted to take out the numerical value, because it's stated in the Fair Labor Act regardless, if they change it, if they don't change it. And then as a committee, you're stating right now that you want employees such as Amanda who are not covered by agreement and are not salaried to follow the union contract. Because we've done that regardless, because they follow the union contract.
Okay, if everybody's agreeable to that, that's fine with me. I mean, I think we know what we're doing, but it's just a matter of having our regulations or policies and agree with it.
Is at the discretion
Alright. So, page 90 has no markups on it. Page 91, which is policy 1040, paycheck. There's a sample policy that I will have to get out, but there is nothing else marked up on that one, so I will look into getting those sample policies again.
I wonder what she would have for a sample policy.
I don't know, I have to go back and look at her emails, and I did request just to resend them all to me because,
I'm just not sure what she would have for a wage and salary policy.
no, because it's specific to our organization.
Right.
But I'll take a look at it and see what I can get from her. But anyways, moving on, this is 1041 paycheck garnishments. There's no markup on page 92, no markups on page 93. So the next policy is paid days, paid period, policy 1042. What again?
1040 was paycheck.
Yeah,
What's policy 1041?
Paycheck garnishment.
paycheck garnishment.
Um,
Get it, girl? Alright. You're fine. 93, no markup, so this would be policy 1042, which is page 94. And this is personnel paid days paid, period. So there is a comment under policy that has a question mark, so let's read it. Policy states paydays are either on the Friday following the end of each pay period unless paychecks, wait a minute, scratch that because Jill apparently cannot read. Paydays are either on the Friday following the end of each pay period. Paychecks will be distributed at a time designated by the county board executive assistant.
The first sentence doesn't make sense.
Well-
Paydays are either on the Friday. See, paydays are on the Friday following. Either is the wrong word should be taken out of there, right?
Yes.
And that would make sense.
Paydays are on the Friday following the end of each pay period unless it's a holiday.
Okay, that's not in there, but you can add that if you want.
Because if it was a holiday, you're gonna be on Thursday. So, yeah, we could change that, that's fine.
Just put like the pays are the 15th.
Take out that. Unless holiday, okay. Alright, so then also under policy 1, 2, 3, 4 paragraphs down, she is just making a language change there, which would be paycheck errors under payment are to be immediately discussed with county board executive assistant and corrections will be reflected on the next paycheck. Okay, so page 95, which would be policy 1043.
Whoa.
Okay,
Paycheck
whoa.
errors, it says underpayment.
Yeah,
What about overpayment?
That's the next sentence.
that's the next one.
Okay.
So she changed underage to underpayment.
Mm-hmm.
The next one is overage.
But why wouldn't that be reflected in the next paycheck?
I don't know.
It doesn't say
It
that.
doesn't say that. So we can add that sentence.
The first one, if you got underpaid, it reflects in the next paycheck, but if you got overpaid, the county never gets their money back. That's what this says. Well, it just says you're gonna report it to Amanda, what's she gonna do?
She's gonna take it out of your next
That's
paycheck.
right, give them your money back.
Yeah, then we can add that sentence, and that's fine. Let's see here, page 1095, which is pension plan IMRF, policy number 1043. Let's see here, no markups on page 95. So then moving on to 96, which is performance reviews, policy 1044. Underneath purpose, there is a comment that states, I recommend using qualifiers like this in some cases, wait a minute. in case some employees are evaluated more frequently or in case an annual performance cannot be completed on time for some reason. So, okay, it states that in an effort to improve job performance and help determine annual increases, all full-time and permanent part-time Iroquois County employees will typically receive an annual evaluation. Okay.
I don't understand why she wants that changed.
I recommend using qualifiers like this in case some employees are evaluated more frequently or in case an annual performance cannot be. That's why it says typically. So we can change that to state, Iroquois County employees may receive an annual evaluation at the discretion of the department head or supervisor. I mean, I don't know, whatever you want to do, typically I think would cover it either way,
Yeah, I mean.
just leave that alone.
Yeah, well, typically doesn't that mean,
You may or may not get one.
Yep.
Alright, so under policy, performance evaluation typically must be completed by the end of the fiscal year. All full-time and permanent part-time employees will receive an annual performance review as of their anniversary date. The evaluations will be prepared by the employee's department head or supervisor and approved by the appropriate department chairman if required. It will be the responsibility of the evaluator to seek input regarding the employee's work performance for the evaluation from other department heads and or board members as appropriate.
I guess one comment I would make about this is that that's why on our agenda we have executive sessions, because we have people for this committee to give performance evaluations to. But because we're trying to get this manual done, we're foregoing those evaluations until we get this done. So that's why that's there, and that's the recognition of this policy that what we're doing, we're trying to get done.
Okay. Let me keep going with the next policy. 1045, personal appearance. Let's see here, there's no changes on page 97. There are no changes on page 98. Which takes us to page 99, which is personnel records, policy 1046. Underneath policy, I'm gonna read it as she suggests, having it written. Personnel records on all staff will be kept in a central location in Iroquois County. The county board executive assistant and employee's department head or supervisors may review an employee's personnel file for legitimate business reasons. The employee may see his or her own personnel file in the presence of the county board office by appointment only within 7 days of the request unless specified differently in a bargaining unit agreement. The employee may review all documents in his or her file except for pre-appointment references or other documents for which access is prohibited in accordance with the Personnel Record Review Act.
First thing that stands out there, that sentence in the middle that says the employee may see his or her own file in the presence of the county board office, should be changed to county board's executive assistant.
Okay.
And where you said in the beginning,
I mean, I've shown
you
people the
said
personnel
may,
policy.
you said department head or supervisors may review, this copy that, oh yeah, there's me, I'm sorry, it was hiding in there.
Yeah.
I didn't see the word, I got it now, excuse
Okay.
me.
So under responsibility, I'll read it as suggested. It is the responsibility of the county board executive assistant or the designee to maintain the confidentiality and limit access to the files only to those with authorization just a grammar change there, which I think is fine. Letter C, the comment is, not every document is going to require an employee's signature. Instead, consider it is the responsibility of the employee, or of the county board executive assistant to ensure that records that require an employee's signature are signed properly. Okay. That's what she's, I'm okay with that, because it says every document, changing the language a little bit, I think it's fine. Moving on to page 100, under procedure. The suggested changes are, upon employment, a personnel file will be established. The department head or supervisor or his or her designee will assure that all documents which require employee signature are signed no later than the completion of the person's first day of employment.
Is that what we do?
Yep.
And if it doesn't get done, then what?
Usually, typically, you know, the completion of the file needs to happen before they are paid. Because in some cases, they make insurance, you know, decisions after they take it home, they review it, they bring it back.
They have 30 days to decide. if they
We
want
let
to
them, like with the computer use policy, we do give them an overview, we do allow them time if they would like to have time, or they're more than welcome to take a copy home, read it and come back and sign. So I would say typically before their first, payday, we have everything signed.
Should we change the wording then to reflect that? That's what we do?
I mean, it would be phenomenal to have it the first day of their employment, but I just don't think that it's realistic in some cases, because even though you consistently tell people, hey, you need to have your social security card and your driver's license, or this, I mean, they always forget something, so we could change it to their first pay, expected pay date, if you wanted to.
I mean, there's no penalty here if it's not complied with anyway, so.
No, so,
But I would say, if we're gonna be realistic and you wanna have the first payday, then maybe that's fine.
that's fine, we can make that change. Okay,
I would suggest that we probably far enough for today.
okay, well,
we-
let's see here, is there any other changes? I'd like to end on like a policy number, if that's okay. You know what I mean, because we're kind of in the middle of a policy,
Yeah, let's get this one
and this
done.
one's almost done, so if we move down to K, the suggestion is that if you state you're going to do this, to make sure it's 100% compliance. So audit employees' personnel files annually and removing information. I think that's fine to leave in, because we review those quite often, actually. Iroquois County will retain all employee personnel files 7 years after separation. We pretty much keep them a little longer than 7 years, so that would be fine. Okay, now we can end on 1047, would that be okay?
Yep.
Yeah, I just prefer to end on an actual policy in the middle one.
It looks to me like there's a reasonable chance we might finish up next month.
Maybe. It depends on your definition of reasonable. See, I put on there quick, didn't I, Charlie?
I don't know.
It's unreasonable guy I know.
Catch up with you.
Yeah, there's so many different ways to interpret things. Alright, so next time we're gonna start with policy 1047, page 102 in a minute.
Policy 1047.
Yep, page 102. Just so you know.
That's what I've got.
Cool beans.
All right, moving along, we're not doing executive session. We hope to have some appointments, but haven't got that all worked out yet, so I can't mention anything there. Correspondence. We received the annual report from Workforce Investment. A lot of information in there. They only sent one copy of the report, so. That is what it is. don't have any claims this morning. Do we have any old business to come before the committee? Do we have any new business to come before the committee? Seeing none, do we have a recommendation to adjourn? Mr. Hall wants to adjourn. Mr. Ducal, wanna agree? Fine. We'll all agree that we will adjourn.